at $100 per employee per pay period for the initial violation and $200 for a subsequent violation, these penalties would add up to be very substantial. In this example, on the left-hand side, under the old PAGA statute, the plaintiffs would also argue they could stack the penalties. So if the employee had a missed meal break, for example, that resulted in the employee not being paid properly, and also meant that the employee didn't receive an accurate itemized wage statement. So they would add these other penalties up. So they would say if it's $50 per pay period per employee for the meal break violation, but $100 per pay period per employee for the wage statement violation under 226 and these other claims. So as you can see, these penalties would stack up pretty quickly. And so just for 100 employees over a period of 2 years with 52 pay periods, a plaintiff's attorney could easily come to the table and say, look, the total liability is $2.3 million and start the negotiations at that number. Now, with the reformed PAGA, I've got an example here, and we'll talk about how this is going to play out. The stacking's not permitted anymore under the reformed PAGA, and the standing requirements are a lot more stringent. The plaintiff actually has to suffer the injury that they're bringing the PAGA claim on. So, for example, if they bring a case, they're going to actually have to suffer the rest break violation and a meal break violation to bring a PAGA claim. And because you can't stack the penalties, if that's the violation, there's a great argument you can't stack the penalties. It knocks out a lot of these off-the-clock claims, unpaid overtime, wage statement violations, things like that. And then at the bottom there, I've got expense reimbursement. That would have to be a separate claim that the plaintiff actually suffered from. And then the reformed PAGA also built in a cap of 15% of the total liability that was available to the plaintiff if the employer is showing good faith effort to comply with the labor code. So if the employer in this example can establish that, the total liability in this case for 100 employees is greatly reduced. You've got a good argument. It's down in the $150,000 range, about a 93% reduction. And that's big for employers, even though this reform is not eliminating PAGA, and we'll talk about that. The fact it's lowering this number that where the negotiations start at and the total potential liability is a huge win for employers. So, it's a vastly different settlement discussion when you come to the table and say, look, I'm only soaking wet liable for $150,000 of total damages as I see it, versus a $2.3 million starting number. Those discussions are vastly different. So it's opening up a lot of arguments for employers going forward.